The morning her son called to tell her the house had been sold, Gloria Watkins was standing in her kitchen making oatmeal. She set down the spoon. She asked him to repeat what he had just said. He did. She thanked him, told him she loved him, and hung up the phone. Then she sat down at the kitchen table and did not move for a very long time. The house he was talking about was not just any house. It was the house her mother had lived in for 41 years, the house where Gloria had grown up, the house her mother had promised to her in a handwritten letter signed and witnessed 3 years before she passed. It was the house that Gloria's younger brother Raymond had been managing on her behalf, or so she had believed, while she finished out her last few years of work 3 states away. The house had been sold 6 weeks earlier. Raymond had signed the papers. The money, $237,000, was gone. And Raymond was not returning her calls. This is the story of Gloria Watkins, a 58-year-old nurse, a daughter, a woman who had trusted the wrong person for the last time, and what she did when she realized that the one person she had never once suspected was the one person who had been planning this for years. This story is about patience, about what happens when a quiet woman finally decides she has been quiet long enough. To understand what Gloria was up against, you need to understand the family she came from. Gloria and Raymond Watkins grew up in a modest but warm home in a small city in Georgia. Their mother, Edna, was the kind of woman who kept her promises and expected everyone around her to do the same. She was not wealthy by any measure, but she had worked for decades as a seamstress and had paid off her home entirely by the time she was 62 years old. That house was everything to her. It was the one thing she had built entirely on her own terms, and she was determined to leave it to her children when she was gone. The arrangement had seemed simple. Gloria was the older child. Gloria was responsible, stable, a registered nurse who had spent 30 years working in intensive care units and knew how to keep a clear head under pressure. Edna trusted her completely. But Gloria lived in Ohio, and Raymond lived 4 blocks from their mother's house. So when Edna's health began to decline, it was Raymond who drove her to appointments, it was Raymond who handled her grocery shopping and her utility bills, and eventually her paperwork. It was Raymond who had her ear in those last fragile years when she needed someone nearby. Gloria called every Sunday without fail. She flew down 4 times a year. She offered more than once to relocate, but her mother insisted she stay, that she was needed at her hospital, that Raymond was handling everything just fine. Edna passed away on a Thursday in November, 2.5 years ago. She was 79 years old. She went peacefully, in her own bed, in the house she had loved. At the funeral, Raymond hugged Gloria and told her he would take care of everything. He said she should go back to Ohio, finish her last year before retirement, and that when she was ready to come home, the house would be waiting for her. Those were the last words he said to her that she believed completely. The first sign that something was wrong came 8 months after the funeral. Gloria had asked Raymond to send her the property tax notices so she could contribute to the upkeep. He kept telling her he had it handled, that she shouldn't worry, that he would forward the paperwork. The paperwork never came. She asked again. He changed the subject. She pressed him directly, and he told her with a slight edge in his voice that he was busy and that she needed to trust him. She told herself he was grieving, that managing the estate had been stressful for him, that she was being impatient. She waited. The second sign came 4 months after that, when a friend who still lived in the old neighborhood mentioned in passing that she had seen some work being done on Edna's house. new windows, a fresh coat of paint, the kind of improvements people make before they sell. Gloria called Raymond that same evening. He said it was just routine maintenance. He said he was protecting the value of the asset, as any responsible person would. His tone was smooth and reassuring, and gave her absolutely nothing to hold on to. She started to wonder, but she still did not want to believe what she was beginning to suspect. The truth arrived on an ordinary Tuesday morning, delivered by her son, who had seen a real estate listing while browsing property records online out of curiosity. The listing showed their grandmother's house, the house under a different owner's name. The sale had been recorded 6 weeks prior. The new owners had already moved in. Gloria did not scream. She did not call Raymond in a fury. She did not post anything on social media or call her cousins or do any of the things that might have felt satisfying in the moment. Instead, she called in sick to work, sat down at her kitchen table with a legal pad, and began writing down everything she knew and everything she needed to find out. She had spent 30 years in intensive care units. She understood that the worst thing you could do in a crisis was panic. You assessed the situation, you identified what was stable and what was not, you made a plan, and then you worked the plan, step by careful step, until the patient either recovered or you had done everything that could possibly be done. This was a crisis. She would work the plan. The first call she made was to a property attorney named Diane Osei, who had been recommended by a colleague. Gloria explained the situation as clearly and calmly as she could. Diane listened without interrupting. When Gloria finished, she said 2 things. She said, "This is serious," and she said, "Do not contact your brother yet." Gloria asked why. Diane told her that in cases involving estate fraud, premature confrontation almost always gave the other party time to move money, destroy documents, or construct a version of events that was difficult to disprove. She said the most important thing right now was documentation, and that every piece of evidence needed to be gathered before Raymond knew he was being investigated. Gloria said she understood. She meant it. Over the next 11 months, Gloria Watkins built a case from 3 states away, during the evenings after her nursing shifts, on a folding table in her spare bedroom, surrounded by folders she labeled in her careful, precise handwriting. The first thing Diane helped her obtain was a full chain of title on the property, a complete legal history of every ownership transfer the house had ever gone through. What they found was deeply troubling. 8 months after Edna's death, a quitclaims deed had been filed transferring the property from Edna Watkins' estate to Raymond Watkins personally. The document had been notarized and appeared on the surface to be legitimate. But there was a problem. Gloria had a copy of her mother's will. She had received it from the estate attorney who had drafted it 4 years before Edna died. That will clearly named both Gloria and Raymond as equal heirs to the property, with a specific provision that the house could not be sold without the written consent of both children. Raymond had filed that quitclaims deed anyway. She also had the letter. Her mother had written it by hand 3 years before she died, a personal letter, witnessed by 2 neighbors, in which she expressed her specific wish that if the house was ever sold, Gloria was to receive her full half of the proceeds, and that the decision to sell was to be made jointly between both children. Raymond had filed that quitclaims deed anyway. The second piece of the puzzle was the sale itself. Diane obtained the closing documents from the county recorder's office. The sale price was $237,000. The payment had gone entirely to Raymond. There was no record of any portion being held in escrow for Gloria, no record of any notification to her as a co-heir before or during the transaction. A title company had processed the sale. Diane sent a formal letter to that title company asking how they had proceeded without confirmation of consent from both named heirs. Their response was careful and uncomfortable. They had relied on documentation provided by Raymond indicating he was the sole heir, documentation that, as it turned out, appeared to have been fabricated. The third piece was the most painful. Diane hired a document examiner to review the quitclaims deed. The examiner's finding was that certain elements of the notarization appeared inconsistent with standard practice for that particular notary, whose other authenticated documents they were able to obtain for comparison.